To the chattering classes, this is your 10-second warning. Subcommittee on Digital Assets, Financial Technology, and Inclusion will come to order. Without objection, the chair is authorized to declare a recess of the committee at any time. This hearing is entitled Dazed and Confused, Breaking Down the SEC's Politicized Approach to Digital Assets. Without objection, all members will have 5 legislative days within which to submit extraneous materials to the chair for inclusion in the record. I now recognize myself for 5 minutes to give an opening statement. Welcome to this important end to our digital assets work for this Congress in the 118th session of the Congress. I've been privileged to lead our Digital Assets Subcommittee, which was established only last year, but has already made history legislatively with the Clarity for Payment Stablecoins legislation and our Fit-for-Purpose Regulatory Framework Bill, Fit 21. Despite this legislative progress on a bipartisan basis, we've been troubled by the fact that the SEC, as chaired by Chairman Gensler, has instead chosen to front-end the work of Congress and insert politics instead of being an independent regulator. He even took the unusual step of releasing his own statement opposing Fit 21 on the morning of the House vote, despite refusing to provide technical assistance as requested by the committee, and I might add, also in contrast to the Biden White House, which did not issue a veto statement on that bill. With over 70 Democrats voting yes on the bill just hours later, it's clear that Chairman Gensler is stuck on an island of his own making. The Commission has a statutory mandate to protect investors, maintain fair, orderly, and efficient markets, and facilitate capital formation. Instead of providing legal clarity so that those who want to follow the law can do so, the Gensler SEC approach has injected even more confusion and uncertainty into the markets and for market participants and consumers alike. How is this protecting the public? Whether it's through politicized enforcement actions or by refusing to share its analysis around the legal classification of digital assets, the SEC has created a lose-lose-lose situation for consumers, founders, investors, and everyone in between. On one hand, the agency has pursued enforcement cases against companies for activities that were not clearly defined as securities violations, leaving investors and businesses in a heightened state of uncertainty. On the other, the SEC's proposed rulemakings and guidance have often been overly broad and difficult and frequently impossible to implement for digital market participants. At best, these rules fail to provide any clarity on how to comply with the law while imposing significant compliance burdens on digital asset firms that don't make a lot of sense. In other words, not fit for purpose. At worst, they represent a de facto ban on the use of digital assets and blockchain technology in the United States. Nowhere has the SEC's prejudice against digital assets been more apparent than in the Staff Accounting Bulletin 121, which upends decades of legal precedent in the custody business and creates an impermeable hurdle for those financial institutions seeking to provide digital asset custody services for their clients, particularly banks and bank trust departments that have the authority, the talent, the compliance procedures to do just that. This kind of politicized, unworkable, and inconsistent approach by Chairman Gensler has made it challenging for business to operate in the United States and has driven many in the blockchain community not to write more letters of complaint to the SEC, but to buy plane tickets, make hotel reservations, and make lease decisions for Singapore, the United Kingdom, and the EU. One report estimates that the U.S. has lost around 14% of blockchain developers since 2018. Even the SEC's approval of the exchange-traded product for Bitcoin and Ether earlier this year only happened because Chairman Gensler tried to overplay his hand but could no longer explain to the courts while the SEC approve of Bitcoin's future ETF, but not propose spot Bitcoin products. While this was a positive development, it took countless hours of manpower, millions of dollars in legal fees, and a full SEC faceplant in the DC Court of Appeals to achieve. Important questions still remain about the precedent that sets for future commissions to follow. I'd like to close by reiterating that the pro-FIT21 and pro-regulatory framework views of the majority and many in the bipartisan does not mean we're against the SEC going against bad actors or modernizing existing rules to incorporate digital asset securities and other unique instruments. We're against SEC enforcement abuse and making it hard for legitimate actors who are trying to follow the rules to do a fine job and bring innovation and technology to our markets. I want to thank our witnesses for being with us today and look forward to your testimony. I now recognize the ranking member of the Subcommittee on Digital Assets, Financial Technology and Inclusion, the gentleman from Massachusetts, Mr. Lynch, for 4 minutes for an opening statement.
Thank you, Mr. Chairman. I want to thank you for holding this hearing in the first place, and thank you to our witnesses for your willingness to help this committee with its work. The title of this hearing appears to preface another attempt by my colleagues to attack the SEC for its actions taken against digital asset companies. Industry advocates continue to push a false narrative that the SEC is politicizing the regulatory framework by picking winners and losers and unfairly targeting crypto firms. I find this deeply ironic given that $119 million was used by the crypto corporations to contribute and influence federal elections just this year alone. If anyone is playing politics, it is the crypto industry, and it appears they're playing it well. As I've said many times since this subcommittee was established, this country has a long-standing history of robust securities laws designed to protect investors and keep our markets stable. Unfortunately for the crypto world, the crypto companies, these laws are not conducive to their business models, which is why they continue this crusade to remain unregulated. We have clear rules that investment companies, including exchanges, brokers, dealers, and clearing agencies, must follow to avoid conflicts of interest and to protect investors and consumers. The digital assets industry continues to push for exemptions to all those legal obligations and bring lawsuit after lawsuit against the SEC. A string of legal victories through the courts validates the SEC's conclusions and proves that these litigious efforts are fruitless. The SEC has consistently won enforcement cases against companies like Telegram, Kik, BlockFi, and Libri, with judges ruling that certain digital assets were indeed securities. While most of the digital asset space has collapsed, it's well known what remains is used to facilitate illicit finance or illegal activity. The lack of appropriate oversight due to noncompliance has made this space a safe haven for bad actors. Companies do not get to pick and choose which rules they follow, and certainly should not be allowed to design laws that provide them with favorable outcomes. By enacting legislation like the FIT21 Act, which I oppose strenuously, which would open the floodgates to mass consumer investor harm, this committee would be the one picking winners and losers. We should not be undermining the good work of the SEC by moving forward with legislation that makes it easier for crypto criminals to do harm. Even Donald Trump is now championing an ill-conceived crypto venture just weeks before the election. He's already pledged to make the U.S. the crypto capital of the planet via light touch regulation and removing the SEC chair. The crypto industry has been responsible for insolvency crises, mishandled user funds, rampant market manipulation, rug pulls, hacks, and turmoil in the market. And these are dangers that investors will continue to be exposed to if we allow this industry to continue to go unchecked. Despite the clear dangers, the army of crypto lobbyists remains strong in their mission to achieve favorable rules for the market. I'm also disappointed to see legislation attached to this hearing that would prohibit regulators from requiring financial institutions to record crypto assets held in custody as liabilities on their balance sheets. This bill attempts to codify opposition to non-binding staff guidance and goes far too far. According to a report by the Federal Reserve in 2023, only 7% of American adults bought or held crypto as an investment. We've spent almost 2 years arguing over a small sliver of our financial sector when we could have been exploring ways technology can improve access to financial services. I urge my colleagues to refrain from being a mouthpiece for the crypto industry and attacking regulators that are simply enforcing the law. Thank you, Mr. Chairman, and I yield 1 minute to...
She's not here.
Okay.
So
I yield back.
Thank you. Gentleman yields back. We welcome the testimony today of Michael Liftik. Mr. Liftik is a partner with Quinn, Emanuel, Urquhart, and Sullivan, where he co-chairs the SEC enforcement practice and co-managing partner of the Washington, D.C. office. The Honorable Dan Gallagher, Mr. Gallagher is Chief Legal, Compliance, and Corporate Affairs Officer at Robinhood Markets and a former SEC Commissioner. Teddy Fusaro, Mr. Fusaro is the President of Bitwise Asset Management. Jennifer Schulp, Ms. Schulp is the Director of Financial Regulatory Studies at Cato. And Lee Reiners, Mr. Reiners is a lecturer at Duke Financial Economics Center and a lecturing fellow at Duke Law School. We're so pleased to have all of you here, and we'll start out with you, Mr. Liftik. You're recognized for 5 minutes.
Chairman Hill, Ranking Member Lynch, and members of the subcommittee, thank you for inviting me to speak today. My name is Michael Liftik. I'm a partner at Quinn, Emanuel, Urquhart, and Sullivan, where I co-chair our SEC enforcement practice and our blockchain practice. Before joining Quinn Emanuel in 2017, I spent nearly a decade at the SEC in various roles, starting as a line enforcement attorney, then as counsel to the enforcement director, and then as Chair Mary Jo White's senior advisor on enforcement. I concluded my tenure at the agency as the deputy chief of staff, working on all aspects of the SEC's mandate. I have worked at all levels of the agency and have seen the issues from many angles. I've been on the front lines of digital asset regulation since 2013, when I spearheaded the agency's first intra-agency group focused on understanding crypto and blockchain technology. In private practice, I have represented many clients in the blockchain industry, from layer one companies to exchanges to investors in crypto projects. I've experienced firsthand the challenges of advising clients in this uncertain regulatory environment. I'm here today on my own behalf and not on behalf of my law firm or any client of the firm. I come before you as someone who worked at the SEC, respects the agency, and believes in its mission. But the SEC has missed an opportunity to become the leading global regulator of digital assets and blockchain technology. Instead, the SEC has refused to issue new rules or meaningful guidance relating to digital assets, and at the same time has engaged in whack-a-mole enforcement that the SEC holds up as a replacement for rulemaking. Rather than be an epicenter of financial innovation, as it should be, and as it is in other contexts, the US has turned itself into a crypto no-fly zone. This approach has stifled innovation, caused companies to move offshore, and ultimately harms US consumers' ability to engage reliably with the industry. My observations today are focused on 4 points. First, we must ask whether framing the debate over crypto through the lens of the Howey test even makes sense. Put bluntly, Howey doesn't work well for digital assets. It is an outdated decision about a catch-all term, investment contract, that imposes a facts and circumstances inquiry on every single transaction at issue. Thus, Howey provides no predictability or certainty. Whether a digital asset is a security is perhaps a statutory question best left for Congress. Second, the SEC's enforcement approach has allowed the law to develop in a haphazard way. Different judges from different federal districts reach different conclusions on critical questions, such as whether secondary market transactions satisfy the Howey test. So the industry and US consumers lurch from decision to decision. Third, the SEC's refusal to engage in rulemaking in the crypto space means that areas that cry out for appropriate regulation to clarify a workable path for digital assets go unaddressed. Fourth, the SEC's approach results in it picking winners and losers for all US consumers. For example, the SEC previously put its thumb on the scale by its long delay in approving the registration of a spot exchange-traded product for Bitcoin. The effect of this delay was to drive demand outside the US, where spot Bitcoin ETPs were available. How then do we move forward? I believe the answer lies in regulatory innovation. The SEC can apply the time-tested regime that has existed for decades, modified to fit this new industry. For example, the SEC can try out different approaches to potential rulemaking frameworks through a sandbox led by its FinHub office. The SEC has broad exemptive authority under Exchange Act Section 36. It can use that authority to selectively and carefully craft pathways to registration for securities, exchanges, and others. With regards to enforcement, I believe that our markets are stronger with vigorous and vigilant law enforcement. The SEC's Division of Enforcement must continue to root out fraud and pursue other violations of the federal securities laws that threaten the U.S. investing public. But at the same time, the division must ask itself, how does the current program and priorities help investors? Perpetual investigations and lengthy litigation into potential registration violations consume vast amount of SEC resources and can harm, rather than help, the very people the SEC is charged with protecting. There must be a better way to address digital assets, encourage innovators and market participants to operate within a defined regulatory regime while preserving safe access for U.S. consumers. Thank you, and I look forward to answering your questions.
Thank you very much. Mr. Gallagher, you're recognized for 5 minutes.
Thank you, Chairman Hill. Chairman Hill, Ranking Member Lynch, and members of the subcommittee, thank you for inviting me to testify today on the SEC's current methods of overseeing the U.S. digital asset markets. My name is Dan Gallagher, and I'm Chief Legal Compliance and Corporate Affairs Officer at Robinhood Markets, Inc. I've practiced law in the financial services industry for more than 25 years, and I served as an SEC Commissioner and Deputy and Co-Acting Director of the SEC's Division of Trading and Markets. Cryptocurrency is a multi-trillion-dollar global market in which tens of millions of Americans participate. The technology underlying this market has the potential to fundamentally transform finance. But for too long, the U.S. digital asset markets and millions of Americans who wish to participate in them have had to contend with innovation-killing federal regulatory uncertainty, especially concerning which digital assets the SEC deems to be investment contracts requiring SEC registration and how tokens and platforms can become registered with the Commission. For years, industry participants have asked that the SEC implement a clear and workable regulatory regime for digital assets and support policy solutions that encourage Americans to engage in digital asset markets through responsible, appropriately regulated U.S. firms. Regrettably, the SEC has not done so. Instead, the SEC has engaged in regulation by enforcement, which is bad for American consumers who want greater access to digital assets. It's bad for the innovation in the blockchain and digital asset industries, and it is bad for the already eroding competitive position of the U.S. with regard to digital asset markets. This is not the way Americans expect our government to work. As Judge Amy Berman Jackson recently stated, and I quote, "The SEC's decision to oversee this billion-dollar industry through litigation, case by case, coin by coin, court after court, is probably not an efficient way to proceed, and it risks inconsistent results that may leave the relevant parties and their potential customers without clear guidance." I could not agree more. While Congress continues to pursue needed legislation in the digital asset space, the Commission has, and has had since 1996, the authority now to establish at least a basic provisional regulatory regime for digital assets. This rulemaking could include registration requirements, books and records requirements, anti-fraud protection for consumers, custody requirements, and transaction reporting, all important protections that would have been handy prior to FTX's collapse in 2022. Unfortunately, the current Commission instead wistfully calls on the cryptocurrency platforms and token issuers to come in and register. Robinhood did, spending significant time, money, and effort to pursue registration. And for all our efforts, in return, Robinhood received a Wells notice stating that the Commission staff has made a preliminary determination to recommend that the Commission file an enforcement action against us. Ultimately, it will be up to Congress to rectify the Commission's failure to act to register both tokens and platforms, and to provide clarity for those which do not require registration. Only Congress will be able to truly provide the necessary long-term regulatory clarity for digital assets. But nothing is stopping the Commission from moving now to provide tailored relief that allows firms to register, even if provisionally, and continue to innovate in the meantime. It has simply chosen and consistently done not to do so. I want to thank the subcommittee for holding this important hearing, and I look forward to your questions.
Thank you, sir. Yields back. Mr. Fusaro, you're recognized for 5 minutes.
Good morning, Chairman Hill, Ranking Member Lynch, Chair McHenry, and members of the subcommittee. Thank you for the opportunity to testify this morning. My name is Teddy Fusaro, and I am the president of Bitwise Asset Management. We are a digital asset and cryptocurrency asset management firm with over $4.5 billion in assets under management globally. We are the issuer of one of the largest Bitcoin exchange-traded products in America, products that were first approved by the Securities and Exchange Commission earlier this year, and a project that we at Bitwise worked on in conjunction with the SEC staff for about 5 years. We first came in and attempted to register this exchange-traded product in 2019. We believe that investors benefit from the freedom to choose to invest in cryptocurrencies and digital assets through the familiar and widely accessible format of the exchange-traded fund. Many types of security and non-security investable assets, from stocks and bonds to currencies, commodities, precious metals, and now in the United States in 2024, digital assets and cryptocurrencies, are packaged into ETFs and ETPs. Through this type of vehicle, investors benefit from the transparency, disclosure regime, and reporting requirements of a regulated offering, while also experiencing the ability to invest through the same channels that they use to manage the rest of their financial lives, either through a financial advisor or through a traditional brokerage account. Exchange-traded funds at large have been one of the most successful financial innovations of the past 30 years. And they present a unique and mutually beneficial framework through which digital assets such as Bitcoin and Ethereum and many other digital assets can be brought inside the regulatory perimeter. We believe that investors will benefit if many more digital assets are approved for trading and listing in such a manner. We also believe that the approval of Bitcoin ETFs came too late. We believe that investors would have benefited from these approvals many years ago, prior to seeing many Americans send their hard-earned money to unregulated and offshore-based cryptocurrency trading platforms, some of which ended up causing Americans meaningful financial harm. While we are grateful that the SEC approved both Bitcoin and Ethereum exchange-traded products this year, we urge the SEC staff, SEC leadership, and the members of this subcommittee to consider the ways in which we can continue to make these regulated investment vehicles available to Americans with more underlying digital assets packaged in this product. They bring meaningful consumer protection benefits and provide much-needed disclosure regarding the risks associated with investing in a new and volatile type of investment. We believe that all parties, and particularly mainstream Americans, will benefit from the approval of more digital asset ETFs. Bitwise has been on a nearly 6-year journey in applying for and advocating for the approval of spot Bitcoin and digital asset exchange-traded products. We applied several times to bring such products to the US market, filing our first registration statement for a digital asset ETP in 2018, followed by our first application for a Bitcoin ETP in 2019. We've submitted hundreds of pages of research and studies to support this effort, and we've met with the SEC numerous times during that period of years, a period that extended over 2 White House administrations and 2 different SEC leadership regimes. Our company also recently expanded abroad with the acquisition of a London-based asset management company that issues ETPs in Europe. We did this in part because the challenge of bringing new products to market at home, while the regulatory regime in Europe offers businesses clarity and the ability to list and launch multiple types of digital asset ETPs. We want that clarity at home. We are optimistic that the commercial and consumer protection success of Bitcoin ETFs that were launched in 2024, followed by the launch of Ethereum ETFs this summer, represent the beginning of a positive trend and a new chapter for the regulation of digital assets in this country, and I look forward to answering more of your questions today.
Thank you, sir. Ms. Schulp, you're recognized for 5 minutes for your oral presentation.
Chairman Hill, Ranking Member Lynch, and distinguished members of the Subcommittee on Digital Assets, Financial Technology, and Inclusion. My name is Jennifer Schulp, and I am the Director of Financial Regulation Studies at the Cato Institute's Center for Monetary and Financial Alternatives. Thank you for the opportunity to take part in today's hearing. The Securities and Exchange Commission's approach to digital assets under Chairman Gensler's leadership can be characterized as an enforce first, make rules never strategy. Because the application of existing rules to digital assets is uncertain or inappropriate, the Commission's current strategy effectively amounts to a ban on crypto activity in the United States. The SEC's approach has subjected those who choose to engage in digital asset-related activities to extreme regulatory and compliance risk, and there is reason to believe that developers and projects that may have otherwise chosen to locate in the United States or serve U.S. customers are choosing to operate elsewhere. The basic problem with the SEC's approach to digital assets is simple. Existing rules do not provide clear guidance to market participants as to whether the SEC's rules are even applicable, and if they are, how they can be complied with. Rather than providing clear guidance to market participants and confronting difficult legal questions raised by the novel characteristics of digital assets, the SEC has claimed essentially limitless jurisdiction over digital assets and insists upon compliance with inapt rules. For example, the SEC's registration rules require disclosures about an issuer's balance sheet and cash flow, but such disclosures often don't make sense or are not possible for software projects that are fundamentally distributed record-keeping systems lacking traditional assets or business lines. And when the development or operation of those software projects is decentralized or decentralizing, there may be no one to make such disclosures. These problems also plague secondary trading because the securities treatment required if a digital asset is registered as a security may preclude other uses of the token, such as facilitating the purchase and sale of goods or facilitating blockchain functionality. Existing regulation is no better for digital asset marketplaces. Crypto platforms allow users to transact directly without the intermediation of a broker and vertically integrate functions that securities exchange rules require to be separated. But even if the functions were disaggregated, the SEC's rules create compliance challenges. For example, the SEC's rules mandate clearing agency rules and procedures that are inapt for instantaneous blockchain settlement. Again, these problems are more acute for decentralized platforms. Decentralized platforms do not custody assets, and they settle transactions on open and audible public blockchains. Traditional custody and market transparency rules are a poor fit for these circumstances. Unfortunately, the SEC has shown little interest in working through any of these issues. Not only has the Commission failed to undertake any process towards rulemaking, but it has refused to engage with market participants seeking guidance. Instead, the agency has led with enforcement. Rulemaking by enforcement is suboptimal for many reasons, including that it creates worse rules. Enforcement actions may provide examples, often a bit light on the relevant details, about what a market participant shouldn't do, but rarely provide a means to understanding what to do. This enforcement-first strategy creates a particularly hostile regulatory environment when actions are brought for failing to comply with rules for which the SEC provides no path to compliance. and that hostility is heightened by the SEC's own enforcement misconduct, including material misrepresentations to a federal district court, that raises the questions of whether the agency is acting in good faith. While the SEC's enforce first, make rules never approach to digital assets is the wrong one, the SEC has the tools at its disposal, including exemptive authority, to undertake a better strategy towards digital assets. It is long past time to put those tools to use. Thank you, and I welcome any questions that you may have.
Thank you for your testimony. Mr. Reiners, you're recognized for 5 minutes for your oral presentation.
Chairman Hill, Ranking Member Lynch, and members of the committee, thank you for inviting me to testify at today's hearing. My name is Lee Reiners, and I'm a lecturing fellow at Duke University, where I teach courses related to financial regulation. Previously, I spent 5 years at the Federal Reserve Bank of New York, examining systemically important financial institutions. The views expressed in my testimony today are mine and mine alone, and do not represent the views of Duke University or any affiliate thereof. Narrative politics refers to the use of stories and narratives in the political sphere to shape perceptions, influence public opinion, and drive political action. Through the use of stories, special interest and political actors seek to influence how the public perceives issues and events, which in turn affects policy preferences and can lead to specific policies being legitimized or delegitimized. Importantly, it does not matter if the narrative is true. What matters is if enough people believe it is true. Over the past year, the cryptocurrency industry has engaged in a classic case of narrative politics. The story they tell is simple, powerful, and false. It goes something like this. There are millions of one-issue pro-crypto voters who stand ready to support the candidates that embrace crypto and ensure the U.S. is host to the next great wave of technological innovation. To make sure policymakers get the message, the crypto industry has amassed an unprecedented campaign finance war chest. As Congressman Lynch noted, crypto corporations have poured over $119 million directly into influencing federal elections, which accounts for nearly half of all corporate spending in the 2024 election cycle thus far. Now, this kind of money buys powerful friends. After previously calling Bitcoin a scam, whose value is highly volatile and based on thin air, Donald Trump recently told the crowd at Bitcoin 2024 that he would make the U.S. the crypto capital of the planet and fire SEC Chair Gary Gensler on day one of his presidency. But more important than supportive statements from presidential candidates is industry-friendly legislation that would hand crypto market oversight to the CFTC and gut our federal securities laws in the process. When the House passed the Financial Innovation and Technology for the 21st Century Act in May, the industry took one large step toward accomplishing their goal. The crypto industry has funded AstroTurf campaigns and commissioned dubious polls to provide policymakers with the cover they need to enact industry-friendly laws and regulations. But the reality is that very few Americans own or use crypto. And among those that do, there is no evidence to suggest that their vote is principally influenced by a candidate's stance on cryptocurrency. The crypto industry has resorted to narratives and aggressive lobbying because it has yet to produce a product or service that provides genuine economic utility to most Americans. In the parlance of startups, crypto has still not found product market fit. To better understand this point, it is helpful to compare crypto's plight to that of another product that came shortly before, ride-sharing. When Uber first launched, its business was illegal in almost every new city it entered. The company overcame this hurdle with one enormously powerful weapon, a product that consumers enjoyed. By solving the problem of unreliable taxi service, Uber quickly developed a large and vocal constituency of riders and drivers. This ultimately forced policymakers to accommodate a business model that forever changed the way we get around. In sum, a great product compelled regulatory change. The crypto industry seems to think the opposite, that regulatory change will compel a great product. This notion has led the industry to become mired in endless policy debates and fitful legislative efforts that only benefit their lawyers and lobbyists. Fortunately, the Securities and Exchange Commission has resisted industry lobbying and upheld the securities laws established by Congress 90 years ago. In my written testimony, I offer context for ongoing debates about the SEC's role in cryptocurrency markets by examining the agency's longstanding, consistent, and legally sound methods of cryptocurrency enforcement and regulation. Many within the crypto sector assert that current securities laws, formulated long before blockchain technology emerged, are ill-suited to the nuances of digital assets. But using advanced technology as a justification for ignoring regulations is a convenient distraction from the truth. The business models of cryptocurrency platforms are fundamentally at odds with federal securities laws. My testimony reveals that the SEC is simply doing the job Congress tasked it with, enforcing the federal securities laws. While crypto market participants may not like these laws, they have no basis to be mad at the SEC for enforcing them. To paraphrase Matthew McConaughey's character in Dazed and Confused, that's what I love about these federal securities laws, man. I get older, they stay the same age. Thank you, and I look forward to taking your questions.
Gentleman yields back. We'll recognize the ranking member of the full committee, Mrs. Waters, for a 1-minute opening statement.
Thank you very much. I'm very pleased to see the SEC holding bad actors accountable, whether they're using crypto or some other means to scam investors. Unfortunately, in less than 2 weeks' time, the government may shut down because, once again, extreme MAGA Republicans are playing games with the salaries of federal employees, including federal law enforcement agencies like the staff of the SEC. So I don't care if you deal in paper stock certificates or if you're dealing in a crypto coin. The law is the law, and the SEC is right to protect investors when you break it. Thank you, and I yield back.
Gentlewoman yields back. We'll turn to member questions. We thank the panel for their discussion. I want to also thank Mr. Lynch, my ranking member during this Congress, our members on both sides of the aisle for their diligent work on digital assets legislation during this Congress, and particularly thank our committee staff and our personal staffs for their engagement on this new complex area in which we've had a lot of debate and some successful legislation across the House floor. Chairman Gensler has often said that the existing securities rules apply to digital asset companies in a straightforward manner, that they simply just need to come in and register with the SEC. He's made that argument here many times. And he leaves the impression, I think, with viewers at home and members of Congress, it just is so easy. It's just like a form out on the SEC's website. Meanwhile, the SEC staff under his leadership continues its very aggressive approach of regulation by enforcement, suing companies that are actually working in good faith to try to, quote, come in and register. And we've now heard that consistently, certainly in this Congress and the Congress previous. Mr. Gallagher, you're the Chief Legal and Compliance Officer for one of those companies, Robinhood, which received a Wells notice from the SEC, and I want to quote from that. After years of good faith attempts to work with the SEC for regulatory clarity, including our well-known attempt to come in and register, we are disappointed that the agency has decided to issue a Wells notice related to our U.S. crypto business. That is in Robinhood's filing. So you attempted to come in and register, I think, as a special purpose broker-dealer, and the commission has approved one of those before. What was it like working with the commission, and what does it say when you want to come in and register? Is it as straightforward as the chairman makes you think?
Well, thanks for the question, Chairman Hill. Look, we heard Chair Gensler's call to come in and register loud and clear. Admittedly, I scratched my head a bit because there was no established regime, at least published regime, but being seasoned securities lawyers, we thought we'll just roll up our sleeves. It's a competitive advantage we have as being a regulated entity at Robinhood. And we committed to coming in and register. We spent about a year and a half, a dozen or so meetings with the SEC staff. We crafted what we believe to be a workable model for registration, utilizing the special purpose broker regime that Chairman Clayton had established in his time, but with modifications that actually made it workable. One thing that's became very obvious to us is that the special purpose broker regime doesn't work for digital assets. So we recommended modifications that would make it work, and we were submitting to full regulation by the commission. And it was a fruitful process. It was very cordial with the SEC staff until about early 2023, when we got a very perfunctory note from the chairman's office telling us that there's no reason to talk anymore. So
It's pretty frustrating to the private sector, and really, I mentioned it in my opening comments about the millions of dollars of legal fees and delays. But in this special purpose broker-dealer, is that a good example? In your testimony, you talk about Section 36 authorities dating back to 1996 on using exemptive relief, using the existing authorities of the commission. Could the commission have modified just the approach to that, the special purpose broker-dealer licensing requirements?
yes, Chair Hill, the SEC could have come out with a more workable proposal than the special purpose broker. If you remember, the special purpose broker was actually a no action letter. It wasn't technically exemptive relief. But as I state in my written testimony, if the commission were to propose a registration and regulation regime utilizing Section 36, and Congress, it's appropriate to be talking about it here, Congress in its wisdom in 1996 in NISMIA gave the commission the authority to exempt certain activities, certain participants from requirements of the securities laws when they deem fit, when it's in the best interest of investors in the country. And in this instance, I would argue that it would be in those best interests to at least for a provisional regime, use Section 36 to craft a registration regime, an oversight regime, books and records, the very basics.
Thank you.
While Congress debates more
I
prescriptive.
appreciate your views on that, and that's why we took the approach of fit for purpose in our Fit 21 bill, was to lay out a framework that the commission itself could have used, and we provide statutory authority both for the CFTC and the SEC. Mr. Reiners talked about that the commission just needs to defend the laws and asserts that maybe we're the ones misunderstanding it here on Capitol Hill. But in my opening statement, I referenced the legal faceplants the commission has repeatedly had before federal courts. I want to insert in the record a op-ed editorial in the Wall Street Journal, September 12th, all the president's legal defeats, including an outline of the digital assets legal defeats by the SEC before the federal courts. Without objection, that'll be included in the record. I yield back the balance of my time. I turn to my friend, the ranking member, Mr. Lynch, for 5 minutes of questions.
Thank you, Mr. Chairman. Mr. Reiners, the SEC efforts to enforce investor protection laws are to ensure market participants are playing by the rules. The SEC investor protection regime is both preventive, making sure our financial markets are not exposed to undue risk, fraudulent offerings, or reckless speculation. And on the other hand, it's also prosecutorial, finding and catching bad actors in the act to prevent more consumers or investors from being harmed. Now, the SEC's enforcement record spans a wide range of actions against a wide range of bad actors, as you know. Earlier this year, the SEC charged 2 individuals with a fraudulent crypto scheme known as Hyperfund. Hyperfund raised about $1.7 billion from investors worldwide, mostly from developing countries. The defendants drew investors in with the promise of high returns from a crypto mining scheme, but in reality, the project was a simple pyramid scheme. Then again, last month, the SEC filed charges against Novatech, alleging that its founders fraudulently raised $650 million from more than 200,000 investors worldwide, again, including many Haitian Americans. The firm's co-founders used social media posts to appeal to their victims' religious faith and promised investors their funds would be safe. Instead, regulators alleged the company was a pyramid scheme, which also ultimately collapsed in 2023. So, Professor Reiners, what can you tell us about how the industry's culture of disregard for securities law has helped create an environment for scams like these two to occur? And what do you think would happen if the SEC surrendered to the industry pressure and established a permissive regulatory framework for the crypto industry to allow that activity to happen more widely here in the U.S.?
Certainly, thank you, Congressman. So I think for every sort of high-profile enforcement action the SEC takes against these larger crypto platforms, there are countless enforcement actions that they're taking against these type of frauds that you just mentioned. You can go to the SEC's website, and it's literally almost every single day. So it's important to note that the SEC is, in my opinion, doing their job as a cop on the beat. But with crypto, it's very hard because there are 20,000 different tokens out there. It doesn't take a lot of work or effort to create a new token and promote it on social media. So it's just a challenging position to be in. I think the risk is that if you pass a light touch regulatory regime, it's going to give the veneer of legitimacy to this industry and draw in more consumers who aren't as sophisticated and who will ultimately be taking advantage of these scams of the variety that you just mentioned.
You talked about, in your testimony, you talked about the lack of a crypto product market fit. It appears to me that crypto operates as a collectible out there. So there's no killer app for it yet. They're still working on that. It sort of operates on the greater fool theory. As long as there's someone else out there willing to pay more for a Bitcoin, it'll succeed. But if people, are lacking confidence in it, like after the FTX collapse, it plummeted. What is the safest way to regulate something like that is purely speculative and operates more like a collectible than as an actual currency with value?
Well, I think as you mentioned, the primary sort of motivation for most people when they purchase crypto is speculation, is to profit. And they're speculating on assets that have, no intrinsic value, right? There's no cash flows that are discounting, right? So there's no sort of valuation model. And in fact, most studies have shown, JP Morgan, for instance, looked at their customers who bought crypto via their JP Morgan checking account and found that most of them had lost money. So I think the solution is to bring it within the securities regulatory perimeter so we can have some just sort of basic investor protections that have existed for over 90 years in this country and that folks are generally comfortable with.
Very good. I do also want to point out that Bitcoin's been around since 2009. So it's been 15 years. And you look at most other technological innovations, usually they have a huge adoption, and that has not happened in crypto. Mr. Chairman, I yield back.
Gentleman yields back. The gentleman from Oklahoma, Mr. Lucas, recognized for 5 minutes of questions.
Thank you, Mr. Chairman. Mr. Gallagher, it's been reported that there is a high rate of staff turnover at the SEC, particularly in the Enforcement Division. Could you discuss the impact of a high turnover rate, what that has, the effect that has on the Commission, and how it impacts the market participants?
Thanks for the question, Congressman. Yeah, the Enforcement Division of the SEC is one of the pillars of the agency. It's critically important. It's how it's measured by the public in many ways. The idea that there's high attrition and that, more importantly, the good people are leaving is very problematic. It really goes to the reputation of the agency. I don't have statistics myself, but I've heard anecdotes. I've heard gossip coming out of the building that morale's pretty low, and so it's definitely a concern.
Ms. Schulp, could you also share your perspective on the issue of staff turnover in the Enforcement Division? How that impacts things?
The Enforcement Division, as Mr. Gallagher said, is one of the cornerstones of the SEC's functions. And high turnover is very difficult. First, the SEC itself, as in an Inspector General report in 2023, more than 2/3 of enforcement staff that had been surveyed said that they did not believe that they had the resources to complete their job. Turnover only exacerbates that problem and leaves other parts of the SEC's function in enforcing other rules as well left to difficulty.
Mr. Fusaro, during the last several years, there's been much attention to the Bitcoin exchange traded products. And the SEC approved 11 Bitcoin ETPs in January of this year. but we've had other regulated futures products for the same amount of time. Could you explain the difference between each product and why investors would want Bitcoin ETPs or futures-based products?
Thank you for your question, Mr. Lucas. Certainly can. So just to clarify the record, the SEC allowed a Bitcoin futures-based ETF into the marketplace in 2021, and then did not allow the Bitcoin spot-based products into the market until this year, as you said. Generally, futures-based products are more expensive for end users. They have disadvantageous tax consequences generally. They're more complex to run, more difficult to manage, and ultimately lead to higher costs and a higher level of difference between the performance of the fund and the underlying asset than you would see in a spot product. Just to give an example, the largest Bitcoin futures-based exchange-traded product has a management fee that is about 5 times as high as the average of the spot Bitcoin ETFs. And since the launch of the spot or physical Bitcoin exchange-traded products at the beginning of this year, the largest futures-based ETP has lagged behind from a performance perspective by about 6.5%.
Could you expand on that about what the consumer demand has been for these products since their approval? Because that reflects how the implementation's done.
Yeah, absolutely. Consumer demand for spot Bitcoin ETPs has been nothing short of remarkable. When you measure the asset growth over the period of time that the group of Bitcoin exchange-traded products has had, the 11 that you mentioned were approved, Mr. Lucas, in 2024, they've taken in net inflows of over $16 billion this year. That is the most successful exchange-traded product launch of all time. And as I mentioned, the ETF industry is one of the most successful financial innovations of the last 30 years. If you look to compare that to what the most successful ETF launch had been prior to this, the popular NASDAQ Invesco QQQ product raised about $5 billion in its first year. And we haven't even had these products in the market for 3/4 of a year. And 4 of those ETFs, those Bitcoin ETFs, have been the fastest, top 25 fastest growing ETPs of all time.
My time's about to expire. I yield back, Mr. Chairman.
Thank the gentleman. Chair now recognizes the ranking member of the full committee, the gentlewoman from California, Ms. Waters, for 5 minutes.
Thank you very much. Since Chair Gensler was sworn in as chair on April 17, 2021, the SEC has filed more than 100 crypto-related enforcement actions, more than a third of which were fully settled at the time of filing. Through these enforcement actions, the SEC has obtained orders for more than $5.5 billion in monetary relief, including more than $800 million in civil penalties and more than $4.8 billion in disgorgement. In most cases, disgorged figures are returned to investors. Additionally, at least 103 enforcement actions were taken during the time that Clayton, who was a Trump appointee, was chair, and then, of course, when Chair White, who's an Obama appointment, was in charge. So having seen that these actions were taken by chairs who are the appointees of different, appointees of both Clayton and Obama, which of any of these actions can any of you point to that you have discovered were absolutely wrong, that the facts were not correct? Which one would you point out that the SEC was involved with settling was wrong?
I'll go first, Congresswoman, and I'm assuming my fellow panelists would disagree with me on this. So, I can't really identify any. Of course, sort of the one notable partial loss in the SEC's track record, of course, is the Ripple case, which I think is important to note, that complaint was filed while Jay Clayton was chair of the SEC, right? So Chair Gensler has just continued on with the approach and the policy of his predecessor. And even in that partial loss, that logic, that ruling has since been, in essence, repudiated by several other federal judges in that same federal district court. So I think, their track record here is very strong.
Thank you. Well, let me just go to Michael, I think Liftik. How are you a crypto attorney?
Thank you, Ranking Member Waters. I am a securities lawyer. I've been a securities lawyer for about 20 years, and a decent part of my practice involves clients involved in the blockchain industry.
Mr. Gallagher, how are you related to crypto? Are you advocating for Robinhood? Is that what you're doing?
Yes, Ranking Member Waters, I'm here on behalf of Robinhood.
And so I understand that Robinhood is attempting to get, license for crypto?
We were, Ranking Member, for a good part of 2022 and into 2023, trying to heed Chair Gensler's call to come in and register. Ultimately, his office told us that there was no path forward.
So has Robinhood been turned down, turned back?
Correct.
Why?
I don't have the rationale. We didn't get an explanation. We just got a stop sign.
That's odd. You don't know why your client was not licensed. Teddy Fusaro, how are you involved with crypto?
Thank you, Ranking Member Waters. I'm the president of a digital asset and cryptocurrency asset management firm. What we attempt to do is take digital assets and cryptocurrencies and package them inside regulated vehicles like ETFs to offer those to the public.
Do you believe there needs to be serious guardrails with crypto to protect the investors?
We do, and we think that the exchange-traded product or exchange-traded fund provides a lot of those benefits. An ETF gives transparency, a disclosure regime.
So do you agree with any of the actions that have been taken, or you disagree specifically with any of the actions?
I don't agree or disagree with any of the specific actions you mentioned. I'm not a lawyer or a specialist on enforcement actions.
Thank you very much. I yield back the balance of my time.
Thank the ranking member. I now recognize myself for 5 minutes for questions. Mr. Reiners, I hope no one's listening to you about this market, especially as a student trying to understand the space. It's over $1 trillion just for Bitcoin. The market's over $2 trillion. Clearly, lots of consumers find value in this space. And frankly, the idea that you could point out that there's only one time that the SEC was even partially wrong has to be willful ignorance. I mean, I don't know how it could be anything other than deceit. It's hard for me to understand, because on August 29th, 2023, the Circuit Court upheld the position that the SEC violated the Administrative Procedures Act when it denied Grayscale's application to convert Grayscale Bitcoin Trust into a Bitcoin ETP. Following that decision, the SEC waited until January of 2024 to actually approve the conversion, and they basically was a pure rebuke of the actions. If you look at DebtBox, another pure rebuke. Lawyers would normally get disbarred for the conduct of SEC in the DebtBox case. So there are lots of cases where they've been caught and told that they were wrong by the courts. And the market continues to reinforce that there really is value, just looking at Bitcoin alone. People right now believe that it's a secure way to store value with a level of confidence of around $60,000. I mean, that's a new security product on the market that you could digitally secure a unit of value, and people believe in it enough to put almost $60,000 into one unit of measure in a Bitcoin. And they don't just want to store it there, they want to be able to transfer it in a permissionless peer-to-peer way. So if you read the Bitcoin white paper available at bitcoin.org, you could see the concept, even if you just read the abstract. It's not just meant to be parked there or speculated on. It's meant to be able to be moved in a permissionless way. Now, we don't know how much of that $1 trillion of market cap in Bitcoin is self-custody versus third-party custody. But the SEC, under Gary Gensler's leadership, has willfully undermined the ability for anyone to custody digital assets, not just Bitcoin, but the rest of the space as well. So they've decided that if they can't completely end the entire space, they want to push custody of it to some third party that they can control or manipulate. They certainly don't want individual American citizens to custody their own wealth and be able to move it amongst others. So, Mr. Fusaro, when you look at this space and the special purpose broker-dealer path that we saw, people saying, we'd love to try to custody digital assets for others, what kind of problems did you find with the current framework offered by Mr. Gensler?
A few of the challenges related to this framework that relate specifically to Bitcoin and crypto exchange traded products that I can mention. One is that as an issuer, an offer of someone who wants to offer these products, the larger and well-established custody banks that typically participate in custody of assets in collective investment vehicles are effectively barred from participating in the space. They don't have a way to bring custody services to the market. That's one challenge. A second one that I'd like to mention is that in the ETF structure itself, or the ETP structure itself, typically the funds have a creation and redemption mechanism that works through what is known as an in-kind process, where the fund exchanges shares in exchange for the underlying asset itself. Because broker-dealers are not able to handle Bitcoin and crypto, we can't have that type of mechanism in the exchange-traded products.
Is that a consistent way that it's applied for ETP, ETF products? Are they treating this differently?
In overseas jurisdictions, we have in-kind transactions that occur in ETFs and ETPs, but it's consistently applied here in that we're not able to bring that type of structure to market, which is a thing that we think slightly increases costs for end users.
Yeah, as the court found, a very different set of rules for this space than the rest of the market. Ms. Schulp, in December 2020, the SEC issued this framework. Have any broker-dealers successfully utilized this framework to custody the space?
I don't believe any have successfully done so. There have been 2 approved, one just last week. The one that had been approved a while ago, earlier this year, actually earlier last year, Prometheum has not operated with most of its services and has only begun offering partial services.
Yeah, thank you. I wish I had more time. My time has, in fact, expired. And I now recognize the gentleman from New York, Mr. Torres, for 5 minutes.
Thank you. The SEC has a pattern of using the term, quote, digital asset security. Mr. Gallagher, does the term digital asset security appear anywhere in any statute enacted by Congress?
Thanks for the question, Congressman. Not that I know of, not until you enact legislation.
Okay. Does the term digital asset security appear anywhere in any rule promulgated by the SEC?
No, sir.
Does the term digital asset security appear in any precedent by the Supreme Court?
Not that I know of.
Okay. Does the term digital asset security appear anywhere in the 2 million pages of the Federal Register?
Not that I know of, unless the special purpose broker-dealer no action letter was in the Federal Register, but I don't think it was.
So if it appears nowhere, neither in rule nor statute, did the SEC invent the term out of thin air?
They certainly created it. I don't know if it came
In
out of
fact,
thin air.
in a recent court filing, the SEC apologized for using the term
Correct.
digital asset security because it's misleading. It gives the impression that a digital asset in and of itself is a security. Is that correct?
I saw that, yes, it's correct.
Now, Mr. Gensler has asserted that all digital assets except Bitcoin are securities. And so I want to examine in detail Mr. Gensler's notion of ether as a security. The textbook example of a security is a stock. Right? If I invest in Apple stock, it means I'm expecting a profit from the managerial efforts of Apple, the company. If I buy Ether, from whose managerial efforts am I expecting a profit? In other words, what is the Ethereum equivalent of Apple, the company?
There isn't one that I know of, Congressman.
Now, in the Howey case, the Supreme Court emphasizes that the SEC must zero in on the, quote, economic reality of a transaction. Since there is no entity that centrally controls Ether in the same manner that Apple controls an Apple stock, would it be fair to say that the economic reality of purchasing a decentralized digital asset like Ether is qualitatively different from the economic reality of purchasing a security like an Apple stock?
That would be fair, Congressman.
Okay. So I have a question about SEC Accounting Bulletin 121. It requires a custodian bank, like the Bank of New York, to put custodial digital assets on its balance sheet, which has the practical effect of effectively banning blockchain and banning the tokenization of real-world assets. And this question is for, it could be for Ms. Schulp if she wants to weigh in. Is it considered good accounting practice for a custodian to put custodial assets on its own balance sheet? Is that customary?
That is not customary. That's typically not how that's handled under generally accepted accounting principles.
It's a violation of generally accepted. Okay, so the SEC is asking banks to violate generally accepted accounting practices and to treat digital assets differently from any other financial asset. Correct me if I'm wrong, did FTX put custodial assets on its own balance sheet?
I believe so.
Yeah.
At least there were a lot of.
Isn't that ironic that SAB 121 contains a cruel irony that it's asking banks to do what FTX did, which is put custodial assets on its own balance sheet? I just find that ironic. When Mr. Gensler was testifying before the Financial Services Committee, I asked him whether the sale of a Pokemon card constitutes a security transaction, and he said no. I then asked him whether the sale of a Pokemon card via the blockchain, whether that constitutes a security transaction, and he equivocated. And he seems to hold that the mere use of a blockchain, the mere process of tokenization, magically transfers a commodity into a security. It magically transforms a collectible, like a Pokemon card, into a security. You know, again, the Supreme Court has said what matters is not the form of the transaction, what matters is the substance, the economic reality of the transaction. If you apply the logic of the Supreme Court to the Pokemon hypothetical, what matters is not whether a Pokemon card takes a tokenized form. What matters is the underlying economic reality of the Pokemon sale, regardless of its tokenized form. So would it be fair to say that the economic reality of purchasing a collectible, like a Pokemon card, is qualitatively different from the economic reality of purchasing a security like an Apple stock? Mr. Gallagher, do you wish to weigh in?
Congressman, I think that would be fair to say. I think there's a minor distinction if you're buying a piece of a Pokemon card versus the whole card. I think that might be a little bit of a different analysis, but I think your statement's fair.
But the value of a Pokemon card does not depend on a Pokemon corporation.
That's
right.
correct.
It's a collectible.
That's
Okay.
right.
I'm done. Thank you.
Gentleman yields back. The gentleman from Tennessee, Mr. Rose, is recognized for 5 minutes.
Thank you, Chairman. I appreciate you, Ranking Member Lynch, holding the hearing, and thank you to our witnesses for being with us today. Mr. Gallagher, it is a pleasure to see you again, and I hope the opportunity to hear you testify in front of the House I had the opportunity last year to hear you testify in front of the House Agriculture Committee in June regarding the FIT 21 discussion draft. As you may recall, during that hearing, we discussed how securities that are not registered are impossible to be listed by a U.S. registered broker-dealer intending to market them to the public. Recently, Prometheum, a U.S. registered broker-dealer with significant ownership from investors with ties to the Chinese Communist Party and the first special purpose broker-dealer license in the U.S., has stated that it will treat Ether, Uniswap, and Arbitrum as crypto asset securities on its platform, despite the fact that the SEC has effectively acknowledged that Ether is not a security, and the remaining assets have not been deemed securities by a court. Mr. Gallagher, can Robinhood list digital asset securities and digital asset non-securities on the same platform if there is uncertainty about whether a given token is a security?
Thank you for the question, Congressman. The answer is no. And that actually was one of the nuances that we requested relief from the Commission for with respect to our application to come in and register a special purpose broker. The special purpose broker letter right now is limited to so-called digital asset securities and will not allow that broker to handle non-securities. I don't know the details of the Prometheum model. It vexes me a bit, given the limitation within the four corners of the letter itself.
Mr. Gallagher, I want to make it clear, I do not believe that these assets are securities. However, suppose we were to accept Prometheum's argument. How can Prometheum legitimately argue that it can make tokens that they assert are securities available to the general public if they have not been registered?
Congressman, to the best of my knowledge, you can't make a non-security a security just by fiat. So I don't know how they can make that statement.
As I see this situation playing out, and I think about one of our witnesses today and the Chair Gensler's actions and the SEC, I'm reminded of the Andy Griffith show back in the day. Many in this room probably remember seeing that show. And, you know, there was the character Barney Fife, the deputy sheriff. And while earnest, he was always enforcing the law and wanting to put people in jail, anxious to get his bullet out and use it. But he didn't have the knack that, say, Sheriff Andy Taylor had for understanding what was good for the people of Mayberry. And it seems to me that we need a Sheriff Taylor who can look at the situation, size it up, and using tools like Section 36 of the Securities and Exchange Act, make the decision that's best for the people of Mayberry. From my perspective, or Mr. Gallagher, at this stage in the SEC's regulation by enforcement approach, is it possible for Robinhood or any U.S. broker-dealer to list unregistered securities for the general public without exemptive relief from the SEC?
It's impossible right now for a regulated broker to deal in both, quite frankly, what the SEC deems to be digital asset securities, as well as just non-security digital assets. The custody rules, the net capital rules, the customer protection rules, none of them accommodate the blockchain infrastructure. So a rulemaking is simply required. The idea of coming in and register is, it's a falsehood.
I think you've technically answered the next question, but what relief exactly would be needed to make listing these assets possible?
Well, Congressman, in lieu of legislation, which I do hope comes, I think as a provisional measure, as I lay out in my written testimony, the Commission could use Section 36 to tailor a registration regime that would just give you the fundamentals of oversight, registration, books and records, things like that. Currently, those provisions, those requirements in the Exchange Act at least, don't accommodate digital assets.
I think the time is not sufficient to get into my next question, so Mr. Chairman, I yield back.
Gentleman yields back. The gentleman from Illinois, Mr. Caston, is recognized for 5 minutes.
Thank you, Mr. Chairman. Thanks to our witnesses. I want to remind everybody that since 2013, the SEC has pursued 173 crypto-related enforcement cases. 100 of those were for fraud. The crypto industry's response to that has too often not been to shut down the causes of fraud, but to claim that because they are decentralized, they are not liable to SEC rules and disclosure, and therefore you don't have to, you're not required to show the fraud. I am specifically concerned about World Liberty Project. This is a new DeFi project that's been promoted by the former president. The details of this were announced earlier this week. And I want to highlight a couple points. That DeFi platform, based on the announcements, says it's going to create a governance token, and 20% of the tokens will be reserved for team compensation, which will include members of the Trump family. That 20% sounds suspiciously similar to the language in the FIT 21 bill that says that if you have more than 20% ownership, or if you have less than 20% ownership, you are decentralized and therefore not subject to regulation. Mr. Reiners, I think you'd mentioned a little bit of this in your opening testimony, but can you just talk about how a venture capital firm or other who owns 20% or less of a protocol's governance tokens could still exert considerable influence over that security?
Sure, thank you, Congressman. So, most of these DeFi protocols, they operate according to a decentralized autonomous organization structure, which in essence requires there to be a governance token so that folks can participate in the execution of that protocol. But those governance tokens are normally distributed to, as you alluded to, project developers as well as backers of the project, in many cases, which is a legal entity or some type of foundation, and those backers are venture capital firms. So even if they have below the 20% threshold, they're still able to exert influence on the project, the protocol, and the people building on it, because of, maybe they have a traditional equity investment in the foundation, in the corporation, whatever that's developing it. So, we've seen several examples of this play out, in various sort of DeFi actions where large VCs have attempted to sort of shape the outcome one way or the other.
And that protocol could be designed in a way that made it more susceptible to fraud, right? I want to stay on that point because they have also, this World Liberty Group has also intentionally said that they will only sell those tokens to accredited investors under the Reg D exemption, which lets them raise money without registering with the SEC. So I guess, Mr. Liftik, I'll start with you. Under the Reg D exemption, would the founders be required to disclose to investors that their most recent investment has lost 70% of its value since March?
Well, Reg D applies to private offering of securities, and the premise...
Yeah, but so they wouldn't have to disclose that information, right?
They need to disclose all material information relating to the investment.
Is that a yes or a no? They've lost 70%. They are currently sitting there trying to figure out if they can liquidate that holding in Trump Media. Would they be required to disclose their pretty poor performance?
I'm not familiar with the details of that.
Okay, well, would they be required to disclose to investors that they have ties to a failed DeFi protocol that suffered a $2 million hack?
I think the point, Congressman, is that if a digital asset project chooses to proceed through a private offering of securities, the Reg D pathways are well understood in terms of the disclosure obligations.
Okay, let's be more specific then. Chase Hero, this guy who's associated with him. I have to clean this up for this promo, but this is one of the guys who's involved in this. He has said about crypto, you can literally sell, I'm going to fix the words, feces in a can wrapped in urine, covered in human skin for $1 billion if the story is right, and people will buy it. I'm not going to question the right and wrong of all that. Would you have to disclose under Reg D that that is the person who's running this venture that you are trying to now sell crypto tokens with? Or would they have to dig that up on the internet as I just did?
Well, typically a private offering memoranda does disclose all the relevant people that are involved in a project. But I think the point for...
But the fact that they have said that this is a venture that is very attractive, let me move on because I want to get to one more point. They have also said that these tokens will be non-transferable and will not earn yield in order to avoid securities law disclosures. I would note that when Fred Trump bought $3 million of casino tokens because his son was missing a debt payment, he did not expect that to be transferred, nor did he expect to earn interest. It was still fraudulent. I understand why people who have a history of fraud, who have a history of laundering money, would find this very attractive. I find it troubling that it is partisan for us to try to shut down ventures that make fraud easier, that make it easier to launder money, and that make it harder to protect investors. I yield back.
Gentleman yields back. Gentleman from South Carolina, Mr. Timmons, is recognized for 5 minutes.
Thank you, Mr. Chairman, and I want to thank the witnesses for being here today. Federal securities laws governing the registration of securities and the broker-dealers that offer them were designed in the 1930s to regulate centralized entities issuing securities primarily to raise capital. This framework is built so that when a company registers to offer security, they are required to submit a number of disclosures that are relevant for investors. However, these disclosures fail to capture many of the unique qualities of digital assets, showing a clear disconnect between traditional regulatory structures and this emerging technology. Let's take non-fungible tokens, for instance. NFTs create trusted, immutable records of digital ownership. The potential applications of NFTs are endless. be it artwork, loyalty points, concert tickets, property titles, or video game items. These unique digital records have transformational potential in almost every industry in the United States. From my perspective, it is clear that blockchains and NFTs they empower are data transfer protocols that support both financial and non-financial use cases. That is why I've been concerned by the SEC treating all NFTs as speculative financial instruments. On August 28th, OpenSea, one of the leading NFT marketplaces, received a Wells notice from the SEC threatening to sue the firm for hosting unregistered securities on their platform. And on Monday, Flyfish Club settled with the SEC for over $750,000 for an NFT offering that simply allowed for exclusive restaurant access. These actions not only represent severe overreach from the SEC, but also suggest that the SEC is engaging in predatory regulation by enforcement. Mr. Liftik, in these cases, did the SEC articulate a standard that they employ to determine whether the sale of an NFT is considered a securities transaction?
Well, thank you for the question, Congressman. I think that gets to the heart of the matter, which is that the Howey test does not work well for digital assets, and in particular in the context of NFTs. As I think Commissioners Peirce and Ueda said in their dissent that they issued on the Flyfish Club, just because the intent of a buyer can't transform something from a non-security to a security, and particularly in the NFT space, as we've grappled with it on the defense side. The challenge is that we consistently analogize to Pokemon cards, collectibles, whether it's arts or watches or baseball cards, and we've not heard a compelling response to that out of the SEC. These are collectible items, each one is unique. They are bought for whatever purpose they are bought for, and trying to apply the Howey test to it simply shows the breakdown in the approach the SEC has taken.
Thank you for that. What has been the impact of the SEC pursuing enforcement actions without first providing clear and consistent rulemaking or guidance for NFT companies to follow?
Well, the challenge then becomes that it becomes a roulette wheel. As you're trying to advise projects whether they can be in compliance or not in compliance, applying the Howey test, it's a facts and circumstances test that applies to each transaction. So going into a project on the front end, a consumer or a company has no way to know whether they will draw scrutiny from the SEC.
Thank you. Ms. Schulp, do you believe that the vast majority of NFTs are consumer products outside the purview of the SEC?
I believe that there are a lot of NFTs that would not fall within the SEC's purview.
Thank you for that. In your view, should the regulation of NFTs focus on the nature and function of these assets or treat them all as financial instruments?
They certainly should not be treated all as financial instruments. The nature and function is important here, and it also goes to the heart of what the securities laws are themselves trying to impact. Those are focused on financial instruments and also focused on the asymmetrical information that the manager or issuer of that asset has over an investor. That's simply not relevant in the case of most NFTs.
Thank you. Chair Gensler continues to mislead and stifle a diverse and innovative tech industry driven by what appears to be a misguided power grab. Unfortunately, the American public stands to lose out as a result. My proposed legislation, the New Frontiers in Technology Act, seeks to address Chair Gensler's unjustified assault on non-financial NFTs by exempting them from securities regulations. Under this bill, NFTs would be classified according to their nature and function, providing clarity as to whether they qualify as financial instruments. By offering a precise legal definition of NFTs, Congress would not only give industry stakeholders the certainty they need to innovate, but also provide regulators with the necessary guidance to apply appropriate oversight. This legislation represents a crucial step toward ensuring that NFTs are properly categorized, enabling their regulation as both financial and non-financial products where applicable. Failure to pass this legislation will perpetuate a flawed system where American innovators face two stark choices: risk unpredictable SEC enforcement or take their ambitions overseas. I know which option I would choose. We need to act on this. With that, Mr. Chairman, I yield back. Thank you.
Gentleman yields back. The gentleman from North Carolina, Mr. Nichols, recognized for 5 minutes.
Thanks so much, Chair Hill and Ranking Member Lynch, for holding today's important hearing on the SEC's politicized approach to digital assets. Not only is Gary Gensler's approach to digital assets politicized, it's just downright wrong. He's hurting consumers, innovation, American competitiveness, and the Democratic administration. In May, 71 Democrats sent a strong message by supporting FIT 21. Our bill regulates digital asset intermediaries, safeguards consumers, and cements the U.S. as a global leader in finance and technology. Also in May, Democrats in both chambers supported my Congressional Review Act resolution with Congressman Flood to rescind the SEC's SAB 121, which puts consumers and the financial system at risk. While these are major milestones, the job isn't done. Unfortunately, the SEC didn't get the message. The will of Congress, and most importantly, the will of millions and millions of our constituents, is falling on deaf ears at the SEC. Under Chairman Gensler's leadership, the Commission has taken the most hostile, aggressive, and irrational approach to technology, although they state that they are technology neutral. This approach is not only against our ideals as Democrats, but it's a real detriment to investors and innovators. The Commission has refused to provide regulatory clarity and has instead over and over relied on regulation by enforcement, taking our country in the wrong direction. I'm very hopeful that we will continue to protect digital innovation in the U.S., protect consumers. Those are the things that we can do in this Congress. Mr. Gallagher, first question to you. Robinhood has been in the crypto space for 6 years, yet it's only now receiving a Wells notice. What would you say is an effective way to regulate a fast-evolving industry like crypto, and how would a more proactive approach from the SEC, such as issuing clear guidelines up front, have changed your company's trajectory?
Thank you, Congressman Nickel. As I stated in my written testimony, I think transparency and clarity, regulatory certainty is the only way to proceed, and we don't have that right now. Regulation by enforcement does not give that to us. And for companies like Robinhood, which embraces regulation, which embraces compliance with the securities laws, that is our main business, by the way, is being a regulated, fully regulated broker and overseen by the SEC and FINRA. We want that clarity. We want to be regulated. You know, some corners of the crypto markets don't want to. We do. We think it's a competitive advantage. And even with that, and even with running what we believe to be a fully compliant platform, we have to look over our shoulder left and right because of this regulatory uncertainty. So as I lay out in my testimony, I believe the Commission should provisionally use their exemptive authority that Congress very wisely gave the Commission in 1996 to craft a regime that will bridge us until the day that Congress can act and give us more prescriptive and comprehensive legislation.
And you mentioned your efforts to engage with the SEC, yet you still received a Wells notice. Can you talk about the level of communication and engagement you've had with the SEC, and do you feel that they've been responsive and transparent in their communications, or has the process been opaque and frustrating?
Well, in the end, it's been opaque and frustrating throughout the process, though. I give the staff of the SEC across all the divisions much credit. It was a very intellectual and lively exchange of ideas. I think they appreciated that we came in as real securities lawyers, and we offered them a solution that would actually give life to the chair's call to come in and register. Otherwise, it's a false promise. We gave it to them, and ultimately the chair's office shot it down. So very frustrating in the end, spending hundreds of thousands of dollars, over 12 meetings with the staff, draft no action letters, taking this very seriously, and then being told there's no process left for us, and then we get a Wells notice on our very compliant Robinhood crypto offering.
Very frustrating. Next question to you, Ms. Schulp. Rescinding SAB 121 is well within the SEC's authority, and there is ample precedent for revisiting a staff accounting bulletin. However, instead of recognizing its misstep and rescinding the guidance, the SEC's Office of Chief Accountant has worked with certain institutions to bypass the balance sheet reporting requirements under certain circumstances. Can you provide us with some insight as to why the SEC would approach SAB 121 in this manner, and what's the impact of this confusing approach?
Unfortunately, I can't provide much insight as to why the SEC is proceeding this way because it is confusing and it's not a good way to regulate. Instead of either revising the guidance or providing clear, different guidance, rescinding it entirely, what we're left with is, quote, non-binding staff guidance in the form of SAB 121 that has been updated by a non-binding staff speech that suggests that there may be exceptions to SAB 121, as well as one-off conversations with the SEC staff. This is not clear at all and provides no level of certainty for market participants.
Gentleman's time has expired. Recognize the gentleman from Wisconsin, Mr. Stile, for 5 minutes.
Thank you very much, Mr. Chairman. If I could start with you, Mr. Gallagher. The SEC recently amended its complaint against Binance, introducing some procedural updates and legal modifications. And in the amendment, the SEC declared that when it used the term, quote, crypto asset securities, end quote, the commission wasn't referring to the crypto asset itself as a security. Put more plainly, the crypto asset is the subject of the investment contract. And according to the SEC, according to the filing, the SEC was using crypto asset securities. That term is a shorthand term, but no longer using it because it's confusing. Can you speak to the amended filing and what the implications are for market participants who may be currently in the SEC's sites?
Thanks for the question, Congressman. I took note of that. I saw the brief itself and found it a very odd admission by the commission that they've been using this term basically out of thin air. I think the net result of it, to your question, is that a real high emphasis is now going to be placed on the secondary market transactions in these assets. And if you recall, the judicial decision in the Ripple case said that secondary market transactions do not give rise to investment contracts.
Is this simply an argument for us to pass FIT 21?
Well, I think you need to pass FIT 21. If this helps, I think it would bolster that case.
Thank you. Let me jump to you if I can, Ms. Jennifer Schulp. Chairman Gensler keeps saying that digital asset project sponsors should just come in and register. If only it were that simple, right? We've discussed many times at this committee our current disclosure requirements for stock and other common investment vehicles really aren't a good fit for digital asset projects. And I think it's important we get this right, both for investors and for issuers. Can you just provide a quick example for the record of how these disclosure requirements aren't a good fit for digital assets?
Sure, and I'll note that the SEC, when confronted with other poor fits for registration requirements for assets, has engaged in other rulemaking to make the fits better. Asset-backed securities are a good example of that. When we're looking at digital assets, the disclosure regime is focused on the issuer itself, where the issuer is, what exactly their business lines are. That's not necessarily relevant when what we're talking about are digital tokens. And the disclosure regime does not cover information that might be important to the purchasers of those tokens, such as tokenomics, such as the token supply, where the tokens are being held back, for project insiders. So investors are getting the short end of the stick here on both sides. They're not getting information that they need, and if they were to follow the SEC's registration requirement here, it's likely that they wouldn't be able to get the information that the disclosure requirements ask for because that information may not exist.
So not only are they not getting the information that you think they would deem relevant for an individual to be able to have, but also the disclosures that they are able to obtain aren't terribly relevant. Is that
correct?
In Mr. Michael Liftik, do you agree with that assessment?
I do, and I think I'd take it even one step further, which is that there is a risk that in applying the traditional disclosure regime, it actually could be misleading to investors because it assumes a connection between the so-called issuer and the security, the equity, if you're talking about ownership shares in a company. But if you're talking about a digital asset and a project that originally minted it, giving all that information about that token minter may have no connection or little connection to the digital asset.
I agree with you. I want to come back to you, Ms. Jennifer Schulp, if I can. The SEC has taken enforcement actions against practically all U.S.-based digital assets trading platforms, including many that have tried to engage with the SEC preemptively to work towards registration. What message does that send to startups, to developers who want to bring their products into the United States?
Well, I think the message is clear. The message is go away. Find somewhere else to do this. The United States is not welcoming.
You're nodding your head, Mr. Gallagher. You agree?
I absolutely agree. And in fact, it's real life for me. We launched our crypto product in Europe last year because there's regulatory certainty, and we couldn't continue to grow and innovate here because there is no regulatory certainty.
Thank you. I think what's so important is that we're working to allow innovation and development inside the United States, not pushing this overseas. I think there's a competitive nature to this,
And what we're going to see is other countries working and developing in this space rather than in the United States. I think it's imperative that we move forward with the regulatory framework. Mr. Chairman, I yield back.
Gentleman yields back. The gentleman from Illinois, Mr. Foster, is recognized for 5 minutes.
Thank you, Mr. Chairman, to our witnesses. Mr. Gallagher, thank you for your time today. You mentioned in your testimony that Robinhood has made difficult choices not to list certain tokens and crypto products. Can you describe the review process that Robinhood follows for determining whether or not to list certain digital assets?
Thanks for the question, Congressman. Robinhood Crypto has a listing process and a listing committee that evaluates tokens for listing, on the platform. Right now, we have 15 coins listed, including Bitcoin, ETH, and other coins.
Yeah, and I believe you've delisted some too, or stopped supporting, I guess, the Cardano, Polygon, and Solana. You've recently stopped supporting. Could you just explain why, the criteria that you applied to say that said these are okay and others are not?
Yeah, thanks for the question, Congressman. Those 3 coins that were delisted a year ago, actually, I think close to the same day we had a hearing in the Ag Committee with Congressman Rose, were listed in the complaint that the SEC filed against both Binance and Coinbase as, in the SEC's estimation, being securities. And one of the factors that our listing committee looks at is whether the SEC has weighed in publicly on the security status of a token. The committee took that into consideration and decided, even though, quite frankly, we disagree with the SEC, we do not believe they're securities, and I have memos from a national law firm saying that they're not.
Yeah. Do you also consider, for example, their use in illicit finance? Is that a factor?
Well, we have a very vibrant AML and KYC function at Robinhood, and so clearly we take these things into account.
Yeah, obviously, our committee spent a lot of time worried about cryptocurrencies' role in illicit finance, ransomware, the whole spectrum, much of which is enabled by the anonymous, permissionless, self-hosted nature of these assets, as well as methods to jump chains, privacy-enhanced coins and back, and mixers, the whole ball of wax. I presume that Robinhood, one of your goals is to not become a convenient on and off-ramp for illicit finance. So does Robinhood currently allow users to transfer their crypto from permissionless self-hosted wallets onto the Robinhood platform?
Congressman, I actually don't know the answer to that question. I do know that
really it's fundamental. If you're trying to not be an on-ramp and an off-ramp to illicit finance, and there apparently, unless there are technological changes I'm not aware of, it is not possible to prevent anonymous self-hosted crypto from being used for those purposes. How do you ensure that when you onboard money, if you could get return for the record, say exactly how it is that you attempt to stop crypto assets that have been used or could have been used for illicit finance, how you attempt to stop those from being onboarded on your platform, and some estimate of how effective that is.
Sure, we're happy to submit that to you. I will tell you, though, we have, as I said before, a very vibrant, what we call the Fin Crimes Group, which conducts very intense AML and KYC reviews generally across the platform.
Okay. Well, many of the frauds that the SEC is charged with preventing, wash trades, front running, investment government frauds. Interestingly, I've been told that these are actually documented in the Babylonian cuneiform tablets. So these are not new inventions, things like, front running and wash trades. And so how do you, I guess this is probably a question for the whole panel. One of the fundamental things, if you're going to have a healthy market, is to have a market participant understand what the market price is. There have been estimates that over half of all transactions in Bitcoin, for example, are wash trades. I don't know, is that still the current number? Does anyone know that that's been superseded? So it's of that magnitude. So how do you understand what a market price is in an object where a majority of the transactions are sort of demonstrably illegitimate, things like wash trades? Is there any technological solution to that, or is that just a fundamental feature of what we're talking about? Yeah, sure.
Yeah, if I may, Congressman, the ETP industry has what I think is a very effective solution for determining what the price of a Bitcoin is. What we use is something called a volume-weighted medium price that uses inputs from multiple different cryptocurrency or Bitcoin trading platforms. You take those inputs in from multiple different platforms, throw out the outliers, and then you average them in time partitions. What we've seen.
Now, are these platforms all SEC regulated, or are these platforms offshore with no clear governance?
They come from multiple different jurisdictions, but
Some of which we have no control over. So that it's not, and that's one of the fundamental problems in understanding what the quote-unquote market price is if there are unregulated platforms on which a lot of the trading, or offshore platforms. Is there a solution to that problem?
So there's a market-based solution, which is that we use this price that is calculated by a third party and includes inputs from many different platforms. But then what we see on the US regulated market with the Bitcoin exchange traded product is that it trades very tightly to that price that we see, that we use as an input for valuation.
All right, my time's up, yield back.
Mr. Sherman's recognized for 5 minutes.
I want to thank the gentleman from Illinois for illustrating what I think we all know. Crypto doesn't work without self-hosted wallets. That's the whole point. That's why they call it hidden money. And with these self-hosted wallets, you have a giant hole in our anti-money laundering system. There's another hole, currency. That's why we only printed up to a $100 bill, the same maximum bill that we had half a century ago. The Republican Party has invested Mr. Trump with substantial governmental power. Even today, he's the nominee of one or two major parties. He's announced that he is now the chief crypto advocate. So on the one hand, he has all that power given to them by the Republican Party. On the other hand, he's trying to make billions of dollars for advocating crypto. That's a conflict of interest that makes Clarence Thomas look like Mother Teresa. We also see that Mr. Trump has advocated that U.S. government money be, quote, invested, wagered on crypto. That means he takes our taxpayer money, gives it to the crypto bros. They get cash. We get whatever the crypto's worth. Maybe it's hamster coin. Who knows what it is? Who knows whether it'll be worth anything in the years to come? We have another Republican hearing aiming at the SEC in order to enrich the crypto bros. Thank God for the SEC doing all it can to protect investors. Sam Bankman-Fried was not one snake in a crypto garden of Eden. He is emblematic of this industry that has a scandal every couple of weeks. Now, we're told that the SEC's, quote, going rogue. No, they're doing what we appropriated the money to them to do. They have the support of the administration. They have the support, I think, of a majority or at least a large number of members of Congress. Every one of the SEC's enforcement action is brought in a U.S. federal court established under Article 3 of our Constitution. Mr. Reiners, are the Article 3 federal courts a proper venue, and do they afford due process? Does the American court system work?
Yes.
That's an easy answer. Now, we're told by the crypto industry that they just want clarity. They don't like the fact that they don't know whether they're security or not a security. Then we're told that somehow, if they're security, the form doesn't meet their specifications. We have, over the last century, developed a system for every other security, every other not intangible investment. It works for soups, it works for nuts. It works for bonds, it works for stocks. And yet the crypto industry doesn't want to apply it to crypto and is spending many hundreds of millions of dollars to prevent that. So I'll ask, we have some crypto advocates here. Would any of you support legislation that would just eliminate this whole controversy and just declare that crypto is a security subject to the same very well-developed standards that we apply to all these other investments? If you're in favor of such legislation, please raise your hand. I'll point out that one witness raised his hand, but none of the advocates for the crypto industry did so. Okay. Let's see. So then we have the DeFi platforms, very analogous to the test we faced for what is a security under the Howley test. Mr. Reiners, is there any difference between, I mean, under the Howey test, if you have the promoter handle your oranges and you get the profits from the oranges, that's a security. Would that also apply to having the promoter loan out your crypto or engage in the lending business and then give you the profits? Does the Howey test make it clear that DeFi lending platforms are a security?
Well, the Howey test is a facts and circumstances based test, Congressman. So I can't sort of speak to a general hypothetical like that. But in many of these lending protocols, the SEC and courts have found that they are in fact securities.
I invite the gentleman to expand on his answer in writing, and now I turn to my friend from Houston. Mr. Green has 5 minutes for questions.
Thank you, Mr. Chairman. Mr. Reiners, in your information that you've shared with us, you indicate that the crypto industry is eagerly pointing to favorable regulatory regimes abroad as an example for U.S. lawmakers to follow, and warning that if U.S. does not act quickly, new and existing crypto firms will set up shop overseas. Do you still stand by that?
Yes.
Okay, let me continue. You go on to say getting it right is more important than being first. You indicate that passing financial regulatory legislation is hard, and once in place, it tends not to change absent some future crisis. You stand by that?
Yes.
And you indicate that we might be looking at some sort of 2008 financial crisis down the road if we don't get it right.
That's correct.
Okay, what is your prognostication? What are you saying? I mean, this is pretty strong language, that's why I'm asking. What are you thinking that will happen if we don't get it right? What will happen?
Well, it's impossible to predict, and I think this industry and this asset class has sort of defied predictions from the very beginning. But again, it comes back to what is the inherent value in these tokens? Again, they're entirely speculative, and now we have these exchange-traded products that are connecting. I call it a superhighway, connecting the traditional financial system with the crypto economy so that a problem in one could easily spill into the other. So you could have a situation like FTX in the future, and I believe there will be another and probably bigger version of FTX at some point in the future, that could cause real damage in the financial system, right? And you could have interconnections just like we saw in the 2008 crisis. And I'll just note, and I can't help but of course be a bit intimidated by the portrait behind you of Barney Frank, of course, one of the co-authors of the Dodd-Frank legislation, I think, which was obviously passed in response to the 2008 crisis, right? So, we enact financial legislation after, major crises, right? We don't, sort of make adjustments sort of along the way. And so my fear is that if we pass a sort of light touch regulatory bill for crypto, it's just going to, again, provide a veneer of legitimacy to this asset class, bring in more people, and then ultimately, there'll be some event where folks get hurt, perhaps a systemic risk event, and then we're back to the drawing board.
Well, you mentioned a crisis, and that crisis that you mentioned had at its root criminality. Is that something that you see as something that we should be extremely concerned about, given the current regime that's proposed?
Well, there's certainly a lot of criminality going on in the crypto industry, but I think the 2008 crisis was more of a kind of classic, speculative mania in housing-related assets, and we've certainly seen speculative mania.
No, but you mentioned Fried. You mentioned Sam Fried.
Sam Bankman-Fried?
Yes, you mentioned him. That's criminality. You brought him into it.
Yeah, I mean, certainly he engaged in a crime. He was convicted of a crime,
Right.
right? But it was a crime that was enabled by crypto. He was able to execute the crime by allowing an affiliated hedge fund to borrow FTX customer assets that were secured by tokens that he minted out of thin air, right? So it was a crypto-fueled crime.
Yes. So it's your opinion that we could have more of this, much more of this?
If what, Congressman?
If we do not take the time to regulate appropriately.
Yes.
Okay. My colleague asked a question earlier, and there was only one person to raise a hand. I'm just curious, do you think that taking our time is something that would cause us greater harm than we might have, we might suffer if we don't immediately regulate? Mr. Gallagher?
Thanks for the question, Congressman. I think the SEC certainly has been taking its time. There is no regulation in place. So, regulation by enforcement, as I say in my written testimony, is just not a way to properly regulate these markets. So I encourage, as I do in my testimony, actual regulation, and I encourage legislation also from Congress.
Well, my time has expired. I am concerned about criminality, and I think that Mr. Reiners makes a good point. I yield back.
Gentleman yields back. I want to thank our excellent panel today, thank our members for their engagement and their questions. Without objection, all members will have 5 legislative days within which to submit additional written questions for the witnesses to the chair, which will be forwarded to the witnesses for their response. I ask our witnesses to please respond as promptly as you are able. This hearing is adjourned.